BEONTV UK, for the community, by the community. www.beontvuk.com.
Lal Haweli Restaurant at the heart of Walsall. BBC Welsh Curry Award-winning chef Abul Hussain presents most unique and amazing tawa dishes with many flavours and choices. Eat with your family and friends. A unique dining experience never to be missed. Lal Haweli, a 400-seat capacity restaurant perfect for any small parties and functions. Special seating arrangements for ladies and families with prayer facility inside. Mouth-watering tawa dishes. Join Tawa Festival at Lal Haweli. Lal Haweli, home of Tawa. 1 Midland Road, Walsall.
Do you want to be part of a historical prophetic Umrah tour? Then book your Umrah with Sheikh Shahid Ullah Azari. Your tour is during October half-term holiday, starting from 21st October till 30th October. Sheikh Shahid Ullah will guide the group personally during the tour. Economy and 5-star package available. Package includes air ticket, visa, accommodation, local transportation and ziyarah. Affordable cost. Discount available for families and early birds. Book your place today without delay as the places are limited. Call 0789 8744234. We wish you a spiritual Umrah. Al-Qibla protected.
Hello and assalamu alaikum everybody. I hope you are all doing well and staying safe. I'm here to talk about non-molestation order and occupation order today. I know these are very technical terms and it will be very difficult for you to understand, but we have a very special guest amongst us to explain this in a very ordinary language, and her name is FAMIDA. She's from Cambridge law firm and she's the associate of the law firm, as well as she's one of the partners of the firm. We will go to FAMIDA Ahmed, but before that I want to say that if you have any questions in relation to family law, it could be child arrangement or divorce, or in relation to non-molestation order, occupation order, you can dial in on our hotline number which is on the screen. So without any further delay, we'll go to our guest. Hello.
Hello.
How are you today?
I'm very well, thank you.
Thank you so much for coming to our studio, and we are glad to have you here.
Thank you very much, Sarah, for inviting me here. It's an honor and a privilege to be here on BEONTV. Thank you very much.
Thank you. So the first question I want to ask you is that we know that you are the partner of one of the partners of the Cambridge law firm. So can you talk more about your firm, which law it specializes in?
Right, yes. We're Cambridge Solicitors. We're based on Warwick Road in Tyseley in Birmingham. We have two firms. We have a main office in Birmingham and we have a second office in Wales, Swansea. The services we provide and the areas that we cover, legal areas, are your normal high street firms. What they would cover is like conveyancing, immigration, family law, wills, probate, just what normal high street areas and services we provide. We're a private firm and we have been established for 8 years now.
Wow, yeah. That's great. And which area you are specialized in?
I specialize in immigration and family law. But the firm does conveyancing, residential, leases, and we cover various different areas.
Okay. So before the show, we have been talking about life, about personal life. Mm-hmm. If I may ask you a question, that beside being a lawyer, you are a mom of 5 kids.
Yes, I am.
That you were saying before
Yes.
the show. So I'll ask that, how do you balance these two different phases of your life?
Right. It's not easy, Saraf. Being a mom and trying to balance home life and work life, it's extremely difficult. But you have to have the passion and the willpower to continue. It's like when I take off one hat, I put on another hat. When I'm at home, I'm a mom, I'm a wife. I'm a sister, I'm a daughter, but when I'm at work, I'm the lawyer. Not only am I a solicitor or a lawyer, but it's my own business. I'm a partner of the firm. So we have the responsibility of running a firm, running a business. So it's not easy. It's stressful at times, but it's nothing that can't be done.
But how do you cope up with everything? Like, have you got any tips for the mother out there who are also working at the same time?
Yeah, I mean, there's pros and cons, but because it's my own firm and I'm there, I can delegate my work. I will take on initial instructions, and we have staff there, we have trainee solicitors there, we have a great team at Cambridge Solicitors, and without that team we couldn't function. So it all starts with the team. Having such a great team, it really helps and assists us. If I was to be working anywhere 9 till 5 and coming home and looking after the children, that would be a bit difficult. But then I have support. You have family support, you have centres, daycare centres, you have like after school clubs, you have nurseries. So we're fortunate that we have those facilities and services available.
Great, that's great. So let's move on the topic that we want to talk about today. So what is non-molestation order? Can you explain this in a very audience language? Because you know it's a very technical term, and it could be difficult for ordinary people to understand what this really means. So can you please explain this?
Yes, a non-molestation order is an order which is granted by the courts to prohibit one person for molestation of another person. So to put it in simple terms, what it means is that if a victim of domestic violence wishes to make an application to court, and we say the perpetrator is the person who performs the act. So the applicant will make an application to court to restrict or put an injunction against this individual to not to harass this person or pester this person or commit any domestic violence. Domestic violence doesn't necessarily mean that it would be physical. It could be any type of harassment, pestering, telephone calls, emails, not necessarily physical.
And could be also attending the property unannounced.
Yeah.
Also publishing on social media.
Exactly.
Could be
exactly.
harassment as well.
Yes. Yes.
Yeah, we can bring all this under the roof of harassment.
Harassment. Yes.
Yeah. And what kind of evidence does the victim needs to show during making
Before
this
I go on to
application?
that, what I'd like to say, you need to understand that the person who makes this application for a non-molestation order has to be the perpetrator, the person who's performing the act. It's got to be an associated person. So there's a definition under the Family Law Act what is or who is an associated person. So an associated person could be a couple, they could have been married, civil partners, it could be a relative. Relative covers siblings, grandparents, children, aunts, uncles. So there's a list of people that it applies to.
Yeah.
So you make an application to court to prevent this person from pestering you or harassing you, and this person has to be an associated person. There's got to be that connection.
Does it mean that the person, can he or she be still married to that person, to the perpetrator, or can he be ex-partner or ex-husband or
you
ex-wife?
don't have to be married. It could be civil partners, it could be ex-partners, it could be, as long as you come under the definition of the associated person. You don't have to be married necessarily.
Right. And what's the aim, really? What's the aim of this non-molestation order?
It's an injunction, is to prevent that person from harassing and pestering this individual. And what an order will have would be its standard clause in there, not to come near a person, not to come 100 yards near that person, not to contact them via email, telephone, WhatsApp, and also third party, not to allow third party to contact them via the perpetrator.
So both directly and
indirectly.
Yeah.
And indirectly.
So for example, so that day I had a client coming in saying that they have got the non-molestation order in place. Still, she went for a shopping with her child, and she got to meet the perpetrator. The perpetrator started to harass her. So does it mean that he breached the court order?
Was there a non-molestation order in place? Right.
Yes.
If a non-molestation order is breached, it's a criminal offence.
Exactly.
And if the applicant
Yeah.
complains to the police, the perpetrator or the person who performed the act, in simple words, in simple lay words, can be arrested. The fine can be imposed against this person and could be arrested and be sentenced.
Yeah, so that's clearly breach of
breach of the order, yes.
So, for example, say there has been previously a non-molestation order in place, but there is no existing court order. But then again, the same situation happens.
Right.
How does it make any difference?
With the non-molestation orders, they are only issued for 3 months. You can always extend them. So if a non-molestation has been issued previously and you feel that there's significant harm or risk to yourself and you're being harassed by this individual, you can apply to the courts to have it extended.
And for how long is the extension?
It'll probably be another 3 months or 6 months. Unfortunately, these orders are not long term. It's to prevent that person at that time, and it's got to be the most recent incident.
Yeah. And how many times can the victim make application for extension?
It really depends. It depends on each case, because if there's significant harm and the courts can see that and it's urgent and they need to put a stop to it, they will do it. You can apply many times.
Yeah. So does it mean that when making application to the court, is there any kind of evidence that the victim needs to provide along with the application?
With the application, what I always do and what the courts do ask for and what is recommended is that you have a detailed witness statement.
Yeah.
With the detailed witness statements, if there are messages you have of harassment or WhatsApp or letters or anything to show that what you are saying in your statements and you've got evidence, you attach that.
Yeah.
It could be photographs, it could be emails, it could be messages, it could be recordings. You always attach that with the application and a draft order, and you have your evidence attached, and it's got to be the most recent incident.
What if the messages are not written, they are voice messages?
You can bring it to the court's attention, and you can ask court permission if they would listen to them, if there's an audio there. You have to bring it, then it's the discretion of the courts.
So does she need to make any kind of, he or she needs to make any kind of
you mention it,
application and the application to seek permission from the court?
Yes. You need to bring it to the court's attention, and they may ask you to seek.
They may ask you to bring the voice messages.
And you need leave from the court.
Yeah, so that's great. And what are the standard clauses on the?
It would be, like I said, not to contact the applicant, not to come 100 meters near where the applicant is, near the house, not to, like we've covered, the emails, text messages, WhatsApp messages, and so forth.
Yeah. Now, when we are saying that emergency non-molestation order, and it has to be that there has been very major incident very recently. When we say very recently, how many days?
It doesn't, each case to its own merit. If you're saying 6 months ago somebody harassed me, the likely chances are 6 months after that, did anybody harass you? Did anybody pester you? Do you feel there was significant risk or harm to yourself? The courts will say, well, it's 6 months ago, no one's come near you. I mean, it's very unlikely.
Yeah.
If you say recently, like a week ago or 2 weeks ago or a couple of days ago, and if there is a very high significant risk of harm to that individual, and the legal advisors will advise them to make a without notice application.
Yeah.
And
so we will go on now without notice application.
Yeah.
We'll come to that point now.
Yeah.
So when you're saying that without notice, what does it mean?
Without notice application means that the perpetrator, the person who performs the act, is unaware that the application has been made. So you make an urgent emergency application to the courts, you highlight the urgency of it. The courts will they will give you a date where you attend. I mean, before COVID, what I used to do, I used to walk into courts on the day with the client, with the emergency application, and submit it there and then, and wait for a judge to be available, present the file to the courts, and if they felt and the judge saw that there is an emergency here and we need an injunction ASAP, they would grant the order there and then. So then once the order is granted without notice, the other party is not aware.
Okay.
Right, but then the onus is upon the applicant to serve that order upon the perpetrator. Once the order is served, then it's at that point it's in force.
Right. So once it's been served, then it will be enforced.
It's been enforced, yeah.
So there is a section in the application form, and when a person is representing herself or himself in person, which is person litigant in person. So there's a section which says that if the property, whether the property is owned by the perpetrator or whether the property is owned by the victim herself or himself. So if we come to the property now, so before we come to the property, we'll move on to the occupation order first. So what is occupation order?
An occupation order can run hand in hand with a non-molestation order. An occupation order is to declare or restrict an individual's right to occupy a property. For example, like we just discussed, the non-molestation order, typical scenario, husband and wife or civil partners, you don't have to be married, and the applicant makes an application for a non-molestation order and is a victim of domestic violence, physical abuse and so forth. That individual is at risk of and is in fear that there's domestic violence involved in here, but they're in the same house, they live in the same house. So then that person can then make an occupation order. The occupation order would either restrict or give that person a right. What it means that whether the property is on your name or not, the individual can make an application to occupy that property because that's their home. That's their family home. So that's your family home, that's where you live, and you need to have some sort of right to occupy it, because if it's not in your name, legally it's not your property, but that's your home. Not everybody who lives together or married has their name on the office copies or the deeds. So it's to protect the individual to occupy that property.
Does it mean that when you're saying that it gives the right of the individual to occupy the property, means that you can stay at the property?
Stay at the property.
And if you are at risk of being excluded from the property, the respondent or the perpetrator can't do that, because there is already an occupation order in place, which means that you can just stay
you can occupy the property. But if the question is, if the perpetrator is violent and if he's in the property, then how would you protect yourself there? So then what you do is then you can make in the same application restrict that person from entering the property or occupying that property, although it's legally his or her property, but for the safety of the applicant, that person would be asked to leave the property, even if they legally own it. So that's why it's either declare or restricts an individual
so does
to occupy the property.
So does it come under the occupation order?
Because that's what the occupation order is. Either it declares, like for example, if the property is not on the applicant's name, it will declare and give them a right to occupy that property. And at the same time, then you say, but you don't want the perpetrator to enter or occupy that property, although the person is legally the owner of the property, it will restrict that person from occupying that property in order to safeguard the applicant.
And probably the children as well, living at the house. So, and the question comes that, what if the applicant is not living at the property anymore? she or he has been excluded from the property, can the person still make an occupation order?
Well, the occupation order is if you want to occupy the property. If you have left the property and you've got an alternative property to for safeguarding reasons or to protect yourself, you've left the property, then why would you want to occupy that property?
Exactly.
Yeah.
Exactly.
Yeah. But there's situations where people are married, and if you want a beneficial interest or a right in a property, a financial interest in the property, then obviously even if you move out and you know you're married to this person or you occupy this property, you can put a charge on the property, a matrimonial home rights charge.
Can you explain that in more details?
For example, if one individual that's a different topic. All in all, it goes to finances. So what actually happens if there's a property there and you're not named on the property, but you're married and that's your matrimonial home, you've had a very long marriage, 10 years, 20 years, 18 years, 15 years, and you believe that, well, that is your home.
Yeah.
And you have a beneficial interest, a financial interest, then under the Matrimonial Act you can register a matrimonial homes charge.
Right.
But that's a completely
different from family law.
Yeah. That's the finances. Yeah, we can get into finances.
Yeah, that's right. So,
but my point to the reason I brought that in, because occupation orders and non-molestation orders are only granted for 3 to 6 months. You can get them extended, but they're not the long-term solution. If you're going through a divorce, then obviously you will have to go through the finances. That's when you put the charge on the property for matrimonial home rights. You go through your finances, and that's how you divide the matrimonial assets.
So, which means that get your finances sorted. That should be that will help you in the long run.
That's in the long run. Occupation orders are temporary.
Temporary, yeah. Just to safeguard you for a very small period of time. Very short period of time.
Yeah.
Yeah. So, can an individual make an application for both non-molestation order and occupation order?
Yeah, they can go hand in hand.
Yeah. Or
majority of the times they do.
Yeah, most of
the times they do. Yes, they go hand in hand.
But can they do any of them?
Yeah, you can do either. Yeah. You can do a non-molestation or an occupation order, or you can do both together at the same time.
The next question, I know I asked this when we're talking about non-molestation order, but then in case of occupation order, who can apply?
Associated person, then again.
Same as the non-molestation order. Yeah. So now we will move on to the child arrangement order.
Okay.
It is, I think, the most common ones nowadays that even though the dad or mom has got parental responsibility, but they have been refused to contact the child. What can be done in this kind of circumstances?
So if you're looking at a typical scenario, mom and dad living together, they separate, they go their own ways, separate ways. The parent that the child resides with decides that he or she will not allow the non-resident parent to have contact with the child. So first and foremost, what we say is that you try to resolve it between yourselves amicably. If that's not possible, you go through mediation.
Yeah.
And that's what courts do highly recommend. I mean, they won't accept your application unless...
What is mediation?
Right, mediation is independent mediators who contact both parties and try to find a middle ground as to why one party is not allowing contact with the child, if they can mediate and try to resolve the issue without the matter going to court. Yeah. Because if you go to court, SARAF, as you can imagine, it's
daunting.
It's daunting, it's emotionally daunting, and secondly, it's time consuming, and thirdly, financially,
it's not cost effective.
It's not cost effective. So that's why the courts always encourage and always expect that parties have attended mediation before making an application to court. Yeah. So if mediation fails, then obviously the the absent parent will make an application to the courts, where then the process will start.
But what's the first step? Because, for example, individuals want to come to an agreement, for example, both the parties are okay to make an agreement on the child contact arrangement. What's the first step to do? Is it like sending out letter to the other party saying that, look, we want to come to an agreement, let's do mediation? Does it
I
work
mean,
like
you can
that?
contact a solicitor who will then, if some firms do provide mediation services, so you'll be the initial letter going out to the other parent to say that you now medically resolve this. If not, then you go through mediation. If mediation fails, then it's through courts.
Does your firm provide that kind of service?
We don't actually do mediation at our firm, but we do signpost where we refer them to and signpost them to mediators.
Oh, okay, that's great.
Yeah.
But from your experience, what do you think that, does it work?
There's no right or wrong answer.
Yeah.
It all depends on the individuals, how cooperative they are, how cooperative they are, and whether they can come to an agreement. It all depends on the circumstances. It depends on the individuals.
It depends on the individuals.
Yeah.
But
Sometimes it works, sometimes it doesn't.
What happens if it doesn't work?
The matter goes to court. You make an application to court. There's a section in the application form where it says, have you attended mediation? If you have, there's a page where the mediator will sign and say, I've tried to mediate between the parties, but it's not going to work. And that mediator has to sign that page. And then the application goes into court. Once the application is in court, the courts will then inform CAFCAS. Now, CAFCAS are officers of the court who will interview both parties, and depending on the age of the child, they may interview the child, because under the Children's Act, the child's interest is what's in the best interest of the child, and they will take into account the children's wishes, feelings, emotions, because the child is paramount. The child is. The courts are not concerned about what issues the parties had between themselves, because the majority of the cases, parents are trying to score points against each other, but that's not the case. You have to look at the child, what is in the best interest of the child.
Because the child is the subject matter of the proceedings.
So once CAFCAS officers are involved, they will interview all parties and they will provide their recommendations.
Right.
That'll be a safeguarding letter.
Okay.
And if the CAFCAS safeguarding letter comes back and there are no safeguarding issues, they would provide their recommendations to say that we recommend that the child should have a contact with the absent parent, and they would put it in their recommendation letter.
Yeah.
And then from there onwards, if parties, I mean, what the safeguarding issues, they'll do all the background checks.
Yeah.
They'll do all this, whether you've been involved with the local authorities, has the police been involved, has the family been known to local authority, and so forth. If none of that applies and there are no safeguarding issues, then they will recommend that the child has contact with the absent parent, because don't forget, it's in the best interest of the child to have contact with both parents.
Yeah. True.
Yeah.
True.
Unfortunately, that doesn't happen all the time.
Yeah.
It doesn't happen all the time. And the parent who the child resides with doesn't necessarily have to agree to the recommendations. And if they don't agree, then the matter will go on further in court, and you'll have direction hearings.
The first one is the first hearing, dispute resolution.
Dispute resolution hearings, then you'll have direction hearings. Then what they'll do, then they will try to come to a
child plan, like how do you want to get in contact during the holiday? How do you want to share the child?
Yeah, but if the other parent, the parent who has residence with the child, if it doesn't agree, then it can go to a contested hearing.
Yeah. And what happens when it goes to the contested hearing?
Well, if it goes to a contested hearing, it depends. It really depends on the issues, because sometimes the other parent will make allegations on the other parent. So then you can go to a fact-finding hearing. Fact-finding hearing, a trial basically, where it's in civil courts it's different to criminal courts.
Yeah.
It will be the credibility. How credible is the individual?
Yeah.
And the balance of probabilities. Is it more probable than not that this person actually did do what the other person is saying? The allegations that have been made, the allegations they are making against the other party.
Yeah. So they will find the truth.
Oh yes, yes, they will get to the bottom of it.
So the other thing is that, you know, most of the time social services get involved.
Yes.
And social services sending out letter to one of the parties saying that, oh, you need to attend to child plan and make an agreement with the other party. So can you take us through?
That would be, with the social services being involved and you have a social worker, that will be in cases where there's safeguarding issues. If there are safeguarding issues, obviously you'll be allocated a social worker and they will be involved, and then there's parenting plans and child in need plan. So it depends again on the individual case. What are the allegations? What are the safeguarding issues? Why are the local authority involved? Because where there's no local authority involved, that's where CAFCAS get involved.
Yeah, right. And
they're like social workers, but they're independent. And they work for the courts.
Yeah,
they're not
neutral.
biased.
Yeah.
They're
neutral,
and
they're accountable to the court only.
Yes.
Yeah. So what if there is an interim order in place saying that granting interim order to one of the parents, he or she can get in contact with the child once in a week. But the issue is that the children are getting scared. Sometimes, anytime soon, daddy might or mom might come and pick me up. Whenever she's or the child is going through that trauma, whenever the child is contacting or in getting in touch with the other parent. So is there any way that this interim order can be contested?
Yes, it can always be contested if one parent believes that this is affecting the child and is traumatizing the child and it's not in the best interest of the child. They can always contact the courts and take the matter back to court. If they've got a social worker involved, they always inform the social worker. Or if you have a CAFCAS officer, you can contact them, speak to your solicitors. If you believe that it's not in the best interest of the child and something is upsetting the child, don't forget, because the child is the center of this battle.
Yes.
And under the Children's Act, it's what's in the best interest of the child.
Right.
Is it in the best interest of the child to have contact with the other parent?
Yeah. Yeah. Okay.
That's
so
what we look at.
What kind of application the applicant needs to make in contesting when she or he wants to contest the interim order?
What you can do, you can take the matter back to go do a C2 application. If your matter is already in court, obviously you will have the next hearing. There'll be directions there. You can bring it to the court's attention at the next hearing.
Yeah. Yeah. So that's one. Now let's move on to the parental responsibility. So many people come without knowing what parental responsibility order, but say that, oh, I want parental responsibility. So can we explain in ordinary language that what PR order means?
A parental responsibility is granted, it's automatically granted to the mother because she's given birth to the child.
Right.
If mother and father are married, father will have automatic parental responsibility. If they are not married, father will only have parental responsibility if he's named on the birth certificate. What parental responsibility allows you is to make decisions for the child. If you need to take the child to the hospital, doctors, schools, to give consent, basically you're responsible for the child's well-being and welfare.
Yeah.
And you're the person or the parent who has that responsibility.
Yeah.
Married couples automatically both have the parental responsibility.
Yeah.
Unmarried, if the father is named on the birth certificate.
Right.
If the father's not named on the birth certificate, and say if the relationship breaks down with the mum and he wants the parental responsibility, he's at liberty to apply to court.
Right. So, so you were saying that the dad has been separated from the mom.
Yeah.
Say, for example, they are not married anymore, and they got divorced, and the dad is not on the birth certificate. So he can still make the parental responsibility order to the court.
Yes.
And what if he wants his name on the birth certificate?
Same, you can bring that to the court's attention on the same application.
Right. So, you know, earlier you were saying that both the parents need to attend the register office.
Yeah.
What if the mother dies? Probably, for example, they booked an appointment with the register office to
And
attend.
the child's not named on the birth certificate.
And
it goes back to making an application to court. It's your C100 child arrangements order application, in which you can, I mean, it's a very broad application. You can have prohibited steps order. I mean, that's another topic we can get into next time. When prohibiting one parent from doing something or removing the child from the jurisdiction. There's lots.
Specific issue. Specific issue
Yes.
order. So there are many kind
There's
of order
many
that comes under child
under
arrangement.
child arrangement. So it's under the one application. So the father can make an application and to apply for parental responsibility. And 9 out of 10 times the courts will allow it. If there's no safeguarding issues, you're the biological parent or the father, they do get the parental responsibility.
Say in a very worst circumstances, say for example they are the same gender couple and they had the baby through a sperm donor. You'll be your civil partners, aren't you? If like civil partners, and same gender marriages are permissible, and you would, both of you would have parental responsibility. So, for example, one of them got removed from the birth certificate, and what happens in that case?
I mean, if you are the parent and you can challenge that, why would you be removed? Because if you're the parent and you've got the parental responsibility, you can always challenge that.
By making parental responsibility?
Making applications. It's the same wide application you make. And once the matter's in court, then you bring it to the court's attention. At that time, the courts will give you directions.
Okay. So now let's move on to divorce. You said that you are doing divorce as well. So what is the most common circumstances in terms of divorce? And recently we know that the law has changed very recently, and
April this year,
what kind of changes?
I mean, the changes we have now, whereas before, if you wanted to make an application, if you wanted to go apply for a divorce, you had to fulfill one of 5 grounds. You have unreasonable behaviour, you have 2 years with consent, 5 years desertion, adultery, and you have I think 2 years with consent, 5 years, and desertion, that someone's gone. So you had 5 grounds that you had to tick one of the boxes. The most common box, or the box that everybody would tick, is unreasonable behaviour, because that would cover any type of behaviour.
Right.
And is a subjective test. It's not an objective test. For example, if your partner came in from work and took his or her shoes off and left them in the middle of the room, and you did not like that, that's subjective to you. You may not like that, but it may not bother the next person. So it was a subjective test. So unreasonable behaviour, what you would do, you'd put down your reasons as I can't no longer live with this behaviour. So that was the easiest way. Or if you've been separated for 2 years by consent, both parties are fine, and you can show and prove that you've been separated. You've got that one, and then you've got 5 years separation without consent. Then there was another one, desertion, if the person's just left. And you can't locate them. So you had to, it was a fault divorce. You had to tick a box for what reason you are divorcing for. What's happened now, it's called a non-fault divorce. You don't need to have a reason as to why you're divorcing. And the application can be made jointly. So whereas before you had an applicant who makes the application, and then you've got the respondent, the other party, the party you're divorcing. Now you can make it jointly, and it's non-fault.
Right.
It makes it a lot easier. It's on the portal, everything's online, and it's a lot faster.
So a few people, they want to sort out finances.
Right.
Right. So should they do before the divorce or after the divorce?
Right. With the finances, obviously, you need to initiate divorce proceedings. So you've initiated the divorce proceedings. Soon as you've made an application, you can start the finances. And I always recommend, and I always say, before you get to the decree absolute stage, so you've made an application, you get to decree nisi, or even before that, you put a stop on that, and you can make well, you don't put a stop on it. Alongside that, you make an application for the finances.
For the finances.
Yeah.
So get it sorted out before
the decree absolute. But
right.
one other thing I'd like to emphasize on, I have a lot of clients who actually just want the divorce and that's it. They get to the decree absolute stage and they just leave it at that. But they don't sort out the finances and they do not finalize the clean break order.
Yeah.
It is so important because at any time the door's left open. At any time the other party could make an application. Although you've gone through you're at the decree absolute stage, and you've moved on, but you need to finalize it with a clean break order. So in future, neither party can bring a claim against each other, because at that time you may have divorced, and if you take it back to court and you believe you've got a case and you've divorced, and at that time due to family pressure or duress, or you weren't aware of the properties and you were a litigant in person and you had no advice as to how to apply for the finances, you take that back to court and you say to the judge, I was a litigant in person, I wasn't advised correctly, whatnot. Although you're divorcing a decree absolute, it can go back and it can trigger off an application.
So it can reverse?
It can't, well, it depends on each case. Well, then they will look into it as to why did you not make that application at that time. You have to provide your statements and evidence and so forth, but that means you've left the door open for the other party to make a claim against you.
Right,
For
in terms of finances.
Finances.
Yeah.
So it's always best to get a clean break order. Once you get a clean break order, you can agree anything on the order. You can say, I'll give you this percentage of the share, or you walk away with what you have and I walk away with what I have, and we don't claim against each other. That's the whole thing of a clean break order.
Yeah.
So it protects you for any future claims.
Yeah. So on the clean break order, it just mentions that how the finances will be separated, how the asset will be separated.
And it's whatever you've agreed upon.
Yeah, right.
It could be an agreed order.
Yeah.
By way of consent.
Yeah.
It's an order by way of consent.
Yeah. So you were saying that many people just leave it like that after receiving decree nisi.
Absolute, even absolute, yeah.
Even absolute. But is there any time limitation in between decree nisi and decree absolute that after you receive the decree nisi, few people without the knowledge, they just leave it like that?
Yeah.
What's the impact?
Right, what happens is you have 6 weeks and 1 day to make an application for the decree absolute. If you leave it for longer, say for 12 months or more, then the courts will ask you as to why. They'll ask you for a reason, and that's when you have to submit a witness statement, giving your reason as to why you've left it so long. Yeah. I've had cases where the finances have taken such a long time, they've gone over 2 years, and then when it's come time for the decree absolute, then we have to submit our client's witness statement and to confirm that the finances had taken so long to conclude, hence why we did not apply for the decree absolute, and the courts accept that.
Wow, that's great. That's great. Yeah. So we will stop there because it's been really very exhausted. It's very tiring day.
We just touched on everything.
Yeah, we have just tried to
touched on everything, but there's a lot more.
Lot more. Just tip of an iceberg.
It is, yes.
So yeah, so Wednesday evening, and thank you so much for coming to our studio.
Thank you for having me.
You have got working tomorrow as well.
Oh yes.
Yeah, and
it never stops for us.
Exactly, and still we are sitting here on a Wednesday afternoon. Yeah. So thank you so much.
Thank you very much for having me.
Thank you.
Thank you very much.
Right. We will finish here, and thank you so much for watching our show today. If you have any inquiry and if you want to get in touch with FAMIDAahmed, and she is a solicitor who is specialized in family law. If you want to discuss your case with her, you can knock on our Facebook page, which is BEONTVUK, and we have got a very dedicated team members behind the camera. They will be able to respond to your messages. They will not give you any legal advice, but they will provide you details of our special guest, who to contact, where to contact. So yeah, and you are invited to watch the next episode, inshallah, and keep your eyes on BEONTVUK. Thank you so much for watching our show. Thank you.
BEONTV UK, for the community, by the community. www.beontvuk.com.
Lal Haweli Restaurant at the heart of Walsall. BBC Welsh Curry Award-winning chef Abul Hussein presents most unique and amazing tawa dishes with many flavours and choices. Eat with your family and friends. A unique dining experience never to be missed. Lal Haweli, a 400-seat capacity restaurant perfect for any small parties and functions. Special seating arrangements for ladies and families with prayer facility inside. Mouth-watering tawa dishes. Join Tawa Festival at Lal Haweli. Lal Haweli, home of Tower, 1 Midland Road, Walsall.
Do you want to be part of a historical prophetic Umrah tour? Then book your Umrah with Sheikh Shahid Ullah Azari. Your tour is during October half-term holiday, starting from 21st October till 30th October. Sheikh Shahid Ullah will guide the group personally during the tour. Economy and 5-star package available. Package includes air ticket, visa, accommodation, local transportation and ziyarah. Affordable cost. Discount available for families and early birds. Book your place today without delay, as the places are limited. Call 0789 8744 234. We wish you a spiritual Umrah.